Good morning, Ms. Contertese.
Please the court, Adriana Contertese for the defendant appellant Kevin Grannum. And also in the courtroom today are two of the amicus writers, Attorney Wayne and Attorney Kane.
Could you speak up just a little bit? Thank you.
In the instant case, the defendant contends that
I can't hear you.
I'm sorry.
That's okay.
Is it on?
Well, there's a sign that says "Do not." Okay, so it seems like it's on there.
Yeah, it's on.
I mentioned that two of the amicus writers are here, Attorney Wayne and Attorney Kane, and now I will say that the defendant contends that the opinion letter of an experienced immigration attorney he submitted to the Dedham court explaining that this conviction would result in deportation.
But based on the, I think the mics just went on. Now maybe I'm too loud, but based on the supplemental materials we received, it seems that the judge in the Dedham District Court concluded that the defendant was not in custody on this conviction, the one you're challenging.
He was not in custody on this conviction.
I mean, that the immigration, he wasn't being held for deportation proceedings because of this, the one conviction that you are contesting.
That's true.
So
he wasn't.
Okay, so how does that affect your argument?
Well, I think that goes to the argument of construing the language of may have rather than has had. Not only does a notice to appear have nothing to do with what the scope of the actual convictions with which the defendant will be charged as a basis for his deportation ultimately. An immigration proceeding is a civil proceeding, so there's no res judicata, no double jeopardy, no ex post facto, very limited due process rights. So that means that even if a defendant isn't deported on particular convictions at a particular time, if they still apply to make him deportable, those can be raised again. That
I understand that, but let's take a step back here. 1999, he was in the custody of immigration.
Yes.
He was for what?
For some other convictions, not this
for a
particular
deportation proceeding?
Yes, for a deportation proceeding.
And this conviction long preceded that?
Yes.
Okay, so immigration presumably knows about this conviction.
They do presumably know about this conviction, and right now...
And are they deporting him, or is there any action to deport him?
No, but that doesn't mean... Right now, the defendant is actively deportable. This is one of two crimes of moral turpitude.
Well, it seems to me it's one of many crimes for which the amicus say he could be deported, including any of these violations of domestic restraining orders. Could be deported for those, too, right?
Well, the amicus speaks to the huge amount of crimes that immigration can choose from.
Including all of the other crimes for which he's been convicted.
Right now, the only two crimes that remain to make the defendant reportable is this crime of moral turpitude and one other existing crime.
How can you say that? I mean, do you disagree with amicus that crimes of domestic violence, including violation of restraining orders, can be grounds for deportation?
No, I don't disagree with that, but I think that based on the defendant's status, the immigration law would apply to make some of those past convictions as a basis for deportation only had they been violations of the restraining order.
And they weren't?
Well,
I thought, what did he serve? What did he go to prison for? A restraining order violation or something else?
I'm sorry, when you refer to prison,
Jail, I'm sorry.
State prison or?
Sure. Was there federal prison as well?
Well, if you're referring to the immigration custody.
I don't mean that.
State prison.
State prison.
State prison.
Well, there's no question that he has a lengthy record of various crimes.
But did he go to jail for one of the domestic the restraining order violations or for something else?
I'm not sure. I know that he has had a lengthy history and has had different times when he's spent in jail. But I know that the two crimes that are making him actively deportable at present is this crime and another crime, only in combination.
What do you mean by making him actively deportable?
Because were the defendant to be picked up by immigration today or tomorrow or next week or in a month from now, this crime and the other crime of moral turpitude together would combine to make him deportable under the statute.
Yeah, may I ask? Go ahead. Excuse me. I'm just curious about how we are to look back at something that happened 12 years ago. He says he didn't get his warnings. All of the records have been destroyed. Wouldn't that put the court system in a horrible position if people could just wait until the records are destroyed and then come in and say, I didn't get my warnings? Shouldn't we just assume that the court system in the normal course of business does what it's supposed to do?
I know that the Commonwealth is really encouraging the court to impose a Lopez kind of presumption of regularity
Right.
to people seeking remedy under the Alien Warning Statute. But first of all, the statute just does not permit it. The language is very, very plain that the presumption should be in favor of the defendant who at any time can approach the court and seek this remedy.
Well, he's been before the court so many times between the time of this supposedly involuntary plea and the present, and yet he's never brought it up.
Well, there may be very many reasons why a defendant would not bring it up. For example, especially if you haven't had the alien warnings, you have no idea that
He
particular
must have gotten
conviction
one
can-
of these many, many times.
Well, we know that starting in 1999, he began to look for relief from this plea. And I think that even the record that was submitted with the appellate brief shows the difficulty that a defendant who is in immigration custody, the difficulty he would have in trying to vacate his plea pursuant to an alien warning statute when you're in custody. Immigration can hold you anywhere in the country they want. They can hold you throughout the entire time. They have absolutely no obligation to transport you to any state proceedings. So this is why the presumption of regularity should not be applied, and also that a defendant should be able to seek this remedy before he winds up in immigration custody.
What about the written waiver form? What happened to that?
Well, I think that there is some cases that address an alien warning on a waiver form, and that is not. And actually, I think it was this court, not the appeals court, that found that that does not do what the
Well, that
alien
would be
warning
some
statute
evidence. I'm
requires.
just wondering what happened to that in this case. Are those forms? I didn't think that paper records were destroyed after so many years, or maybe they are.
Yes,
but
they are.
they
But
are.
docket sheets are not, correct?
Docket sheets are not, and there are docket sheets in this case.
But
and the docket
under the
sheets-
statutory presumption of 27829D, the docket sheet, as I understand it, has to accurately reflect that the warning was given as required by the section. Does this docket sheet reflect that?
No, there's absolutely no notation on the docket sheet of alien warnings at all. And as a matter of fact, I mean, this notation on the docket sheet, really, the docket sheets didn't really start having this pre-printed language with the box you could check until, I think, the middle 90s, although it varies from
Ms.
court to court.
Contantes, I don't know. I mean, I understand, all these questions and, about whether or not these are deportable, but it seems to me that 27829D is where we have to start and end, correct?
Well, especially in light of the decision from the other day, when this court was so careful about construing
I mean,
the
isn't that what
dissemination-
we're guided by? And that deals with, any time it deals with the statutory presumption, it deals with all of those. Isn't that pretty much where we are?
There is no question that this statute was meant to be helpful to an immigrant that was in this spot, and the 2004 amendment makes that even more clear. The legislature wants an immigrant to have this presumption, and the statute wants an immigrant to be able to seek this remedy anytime, and it wants the immigrant to be able to seek this remedy before he's actually put in immigration proceedings.
Is it your claim, as I think the amicus makes this argument, that assuming the statute has not been complied with, which is your claim, and accepting that for purposes of argument, that any time someone who is not a citizen has been convicted of a crime that is on the list of deportable crimes, that's all that needs to be shown? Is that basically where you come down? That satisfies the may language in the statute?
Well, I think it's case by case. I think I think that the amicus brief referred to some language about maybe something that indicated maybe more than something like a citation. that somebody who had some knowledge about the interplay between, that was the language they used, the interplay between criminal law and immigration law.
I don't understand your answer to Justice Watsford.
Well, for example, I don't think that maybe just putting a copy of the relevant statute in the addendum might be enough, although it very well may be. But I think that the district court...
I think the question is if this letter, if this person was convicted of 20 different offenses and one is at issue here, let's put all that aside. A letter from a lawyer saying this one crime is a deportable offense. That standing alone means that the person faces deportation or may be deported on the basis of this. So that's sufficient.
Absolutely.
Just a letter from a lawyer that this crime's on the list of deportable crimes.
Well, but this is a letter from a lawyer showing what the authority is that indicates that this person could be deported.
But my point is, I accept that. It's really that it just has to be a deportable crime. Let's assume you have competent evidence that it is a deportable crime. But there needs to be no further action in terms of getting the defendant closer to actually being deported. Just the fact that he or she has been convicted of a deportable crime is enough to satisfy the may in the statute.
Absolutely. I think that that is what the statute planned for. The statute did not plan for the development that we see more in the appeals court, where you really have to be deported already to get a remedy.
Now the statute speaks of may have one of the may have or has one of the enumerated consequences. Am I correct that the enumerated consequences go back earlier to the statute as to what the warning must be, which is that it may have the consequences of deportation, exclusion from admission to the United States, or denial of naturalization? So are you saying then that if the consequence would be that if he were to seek naturalization, he'd be denied, that too is sufficient?
Yes, because it's one of the enumerated consequences. In this case, were the defendant to seek naturalization, I think the letter refers to that, not only would he be denied, but he most likely would be deported. He would be picked up at the naturalization interview. I think that my sister has submitted a supplemental appendix, and just to clarify, there is an application that the defendant made at some point for which he was refused, but that was not an application for naturalization. That was an application that he had made some time ago for derivative citizenship, which is completely different from naturalization.
So did Attorney Silverman here have this person's entire record, or was he simply asked to look at these two crimes and tell us whether or not these would be deportable?
These crimes were my problem at the time when I approached Attorney Silverman. Attorney Silverman did know this defendant. Attorney Silverman was really nice and had helped me a lot. So he did have some knowledge of the defendant's problems, but it was really this case that we were working on. And there's really nothing in the alien warning statute that says, you know, if you have other crimes or other convictions that may result in your deportation that are pre-existing, that's going to bar your relief. The statute doesn't say that. I know that the defendant does have a record, and maybe in some view or some perspective might not be deserving, but nonetheless, the statute and the legislature really dictates that he have this remedy when he can meet the requirements
because
of the
it's hypothetically possible that this crime might contribute to his deportation? Is that what you're saying?
Well, I think it's more than hypothetically. I think that it's a reality. He is eligible for deportation.
He may be eligible for deportation for a whole bunch of other crimes as well. Isn't it hypothetical that this crime would result in or might result in his deportation? This crime for which he paid a $100 fine back in 1986 as opposed to the crimes from which he was sent to prison?
This crime may result in his deportation at the discretion of immigration.
Hypothetically, if immigration were to decide to base a deportation proceeding on this and other things, it might contribute.
It would contribute. It would be the basis. This would be one of the basis of his deportation were immigration to want it. And I think that that's more than hypothetical. It's a reality. The existence of this conviction and the fact that it is a predicate offense and that he has another predicate offense that makes him actively deportable makes this more than something hypothetical. That's the way that the court has always interpreted this language in Mahadeo and Jones.
Well, we've always looked to sort of whether or not there is actually something that's real that's happening or about to happen.
Well, I think about to happen. I think that is exactly what we're saying. It could happen at any moment. Now, once somebody...
It happened in 1999, but it wasn't based on this.
It wasn't based on
This
this.
is long after this.
It wasn't based on this. And for some reason, immigration just decided never to amend that charging document to include this conviction this time around.
Well, what was it based on? Which conviction?
I'm not sure there were a number. I know that it would have started with. Well, the problem is, and that I think is in the supplemental appendix as well. And this is a great illustration of how immigration can chop and change their case, how this limited due process operates. Because there was a big, thick notice of filing by immigration filed after the defendant had been in custody for some time, that showed a big, thick stack of convictions that immigration could essentially have picked
They
and choose
obviously
from.
let him go because they didn't deport him, right?
They did, but that was also up to their discretion. The defendant had no control over this.
Thank you, Ms. Constantine.
Thank you.
Good morning, Ms. Lee.
Good morning, Your Honors. Tricia Lee for the Commonwealth. This court won't read a statute to produce absurd results. Yet that if we accept the defendant's reading of the statute, that is what we will be left
Well, Ms.
with.
Lee,
No.
are you...
Go ahead.
The language is very clear in the statute, and you would have us treat it as though it didn't matter.
Well, I think looking at the statute itself, we see first that it says...
I'm talking about the record part of the statute.
Yes, the record part. If the statute itself says essentially absent a record that warnings were given, and that can be interpreted to mean there never was a record. There's a record, but it's missing some type of information, like an unchecked box on a docket.
But there's a
unsigned green
presumption.
sheet,
There's a
something.
presumption that they weren't given, right?
Or it could mean that there is a record and it shows warnings were not given, like if we do have a transcript, or if it was inadequate warnings. That is when the statutory presumption can apply. But what this court, what the Commonwealth is urging this court to adopt at this time is that absent any record, because of the passage of time...
No, I don't think so, because I mean, 2004, the legislature surely knew that there was regular destruction of written records, correct?
Correct.
And it specifically enumerated the docket, and we keep dockets forever, correct?
Yes.
Is there any reason why the Commonwealth couldn't have asked to have reflected on the docket alien warnings given?
I can't go back to 1987 and say what
Okay,
the ADA
but since
should have said.
2004,
Right, but...
does your office now ask
Well,
to...
I think now it's more common to see a notation on the docket. It's
No,
pre-printed language.
my question is, does your office ask for
For it to be noted.
on the docket?
Well, I think that in combination of it being pre-printed on most of the dockets now that you'll find in the district courts and Superior Court, you also see a green sheet that's commonly used where the warnings are
I
being
understand. The
used.
problem with the green sheet, though, is that that'll become part of the files that are regularly destroyed, correct?
True.
The only court record that, to my knowledge, that is not regularly destroyed is the docket, correct?
Correct.
And it seems to me that the legislature knew that because it specifically mentions the docket.
That may be so, and in 2004, that amendment and that language that was added only applies to cases from 2004 and onward. And we're looking at cases from 1987.
Why do you say it only applies to cases from 2004?
The effective date. I think by saying that the effective date of the statute applied at 2004, and I think that then we can interpret it as being that the language that superseded that, which just said any record, absent any record, I think that's the language that would apply to cases that were pled guilty or there was a plea of guilty previously to 2004. And at that time, certainly in this case in 1987, it was not the common practice to have a notation on the docket or to use a green sheet. So the only documentation that the warnings were given in this case would have been found in the transcript, which was properly destroyed pursuant to court rules in this case.
Wasn't the
SJC-10516.
presumption in the statute from its inception in 1978?
Yes, the presumption was in the statute before that. But if we're reading the statute now, we're then saying that the statute would it essentially only applies or only gives a benefit to non-citizens. Then we are saying that non-citizens...
But the legislature, this is a provision, 278-29D, is a provision that by its very terms applies to non-citizens.
Correct.
Right. So only non-citizens are subject, potentially subject to
Enumerated consequences.
which can be very drastic.
Right.
Correct. So for you to say, well, the legislature has only protected non-citizens,
Well, of course, the statute is protecting non-citizens from
the enumerated,
consequence of which they were not warned.
Yes,
but I don't think the
but
intent.
it's not giving them any additional protections that that citizens.
Well, I think if we give them a completely different standard of review and say
Not a
that
completely different
if
standard
the
of
presumption
review.
of regularity applies to only citizens, then we are saying that when it's a motion to withdraw the plea, it is a more favorable burden
But Ms.
to
Lee,
meet for non-citizens.
as we
is the
frequently say
legislature.
up here, that's an argument that you take to the legislature, and it seems to me that the legislature has made that pretty clear.
I think in light of the Lopez decision of this
But Lopez
court,
didn't deal with
it
immigration
doesn't.
warnings.
And I know that in light of also Rezafusky and Price, where this court declined to comment on the applicability of the presumption of regularity to immigration cases, the legislature did not then adopt any language that definitively prohibited the application of the presumption of regularity, nor insert any time language like we see in the proceedings.
No, I
the
understand
at
that.
any time language.
The difficulty, do you understand the difficulty is the language of the statute?
I do understand that. But I think that if we look at what the legislature's intent behind the statute, it was not to just wipe clean the records of non-citizen defendants for nothing other than their say-so, which is what we have here, only a self-serving affidavit.
Could I just ask you about one other provision? We've had a
Sure.
lot of discussion about, other potentially deportable offenses. The first sentence of the second paragraph of 278-29D, if the court fails to advise a defendant and he later at any time shows his plea and conviction may have or has had,
An enumerated consequence.
right? I took it the has had meaning,
Already been deported, which is, I think, what was clarified or reiterated in 2004 when the language was amended to say, even after a defendant's been deported.
correct.
I think the may have language, as this court said in Berthold, in Rezafusky, and Price, requires more than simply pointing to a federal statute, because then there's no burden. That would just mean that relief is automatic. And as this court said in Berthold, that would be reading the requirement right out of the statute and make this language superfluous. I think there's a way to interpret this language where more is required. And if we look at may have or has had an enumerated consequence, that could be, for example, distinguishing between a defendant who has already been deported or a defendant who has been notified by Homeland Security that he may be deported.
Okay. And what if I've been convicted of a minor crime and I would like to become a U.S. citizen?
Right.
And I'm thinking about applying for naturalization, but I understand that crime would prevent me from becoming naturalized. Is that all I need to say? Is that
Well, I think it may prevent you. I don't think it's proven or shown, or maybe there are other factors besides one offense, like the defense has argued that there are 2 offenses of moral turpitude that would make him deportable. I think until you have some type of notification that you are either may be denied relief.
No, but have you filled out a request to be naturalized, or were you born here?
I was born here.
Well, I'll just tell you, there are lots of questions, and if you go, no, 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 and you hit the yes box, it's, given our absolutely legitimate attempts to, manage the population here, I think it is not unreasonable to presume that that will give rise to a claim that you're not eligible for naturalization.
And I think in those situations, what the statute itself says, at any time, a defendant may move to withdraw his plea and show he's suffering from an enumerated consequence. And looking at that language, that doesn't mean that at any time relief is foreclosed. It just means that at this time, it's so much of a possibility, it's a hypothetical, that we are saying that the claim is not ripe. The remedy is not available yet.
So going back to my hypothetical, you say that the mere fact that I'm pondering applying for naturalization, recognizing that I'm going to have to answer yes to the question which Justice Marshall mentioned, is not enough. I have to actually go and apply.
I say that that's what Berthold, that's what Rezafusky, Price, all these other decisions of this court, as well as the appeals court, have held that more was required than simply doing that.
Now I'm an alien, and I've had this minor conviction. So you're saying I have to apply to be naturalized. I have to say yes to the question, recognizing that now may result in my deportation. Not only may I be denied naturalization, but now I can be deported. So I have to actually go ahead and markedly increase my risk of deportation before I can apply to seek the, to vacate that
Well,
early
and
conviction.
that might be a result, but once again, that's something, a potential, it's a possibility. And if we did not require more of a showing by a defendant than simply pointing to a federal statute and say, this is a criminal offense and this could make me deportable or suffer from any other of the enumerated consequences, then what we are saying is simply that a defendant, particularly when all records are destroyed, must just stand up and say, I am a non-citizen convicted of X offense. And that would be enough under the statute. And I don't think that's enough under the statute, which
It may be
requires
enough
the-
under the statute to have, to have the statutory presumption apply.
Excuse me?
It may be enough under the statute to have a statutory presumption apply. If there's a docket, if the records haven't been destroyed, if a whole variety of other things have happened.
If the records haven't been destroyed, I think then we have a different story, because then we know whether or not a defendant has been warned of the specific consequence that he is now facing. And that's another thing that we see in previous decisions of this court, where if a defendant comes forward and has a transcript or a record of the warnings that he was given, and it did not warn him of a certain consequence, if that's not material to the enumerated consequence he is actually facing, then that does not give him a right to withdraw his plea under the statute.
Now, I take it the judge retired in this case?
The judge has retired.
And what
long
about
since.
the prosecutor?
Most of the, our file in itself does not even mention who that prosecutor was.
Was there any attempt to get affidavits from the judge or from the prosecutor to the effect that at this point in time the judge was regularly giving the alien warnings in all cases?
Not that I'm aware of, no.
Why didn't you try to get those affidavits?
I think part of the problem with saying that we're going to just ask for a customary practice, particularly in this case, where it was 12 years just since he moved to withdraw the plea.
It'll be longer. It'll be longer.
It's over 20 years now since
But
he
no,
pled guilty, but-
it'll be longer if you require actual deportation or actual immigration processes to start.
I don't think that's necessarily true, because as soon as a defendant is aware that there's some type of consequence, and in this case we can certainly say that someone with a career criminal who has more than 90-plus entries on his criminal record will become aware of the consequences at some point. And certainly in this case, there's evidence that that was the case. In 99, he was not being deported or suffering any consequence because of this conviction.
So why
but because
wouldn't
of
you
others.
why wouldn't you get the affidavits of the prosecutor and the judge?
I'm unsure why that wasn't done here, but I think that then we're looking at just what a recollection was, and a lot of times it's
Well,
more
that's
likely
worked.
that they don't have a
but
recollection.
that's worked in other cases, hasn't it? The affidavits?
If it's a customary practice of the judge, and then I think a lot of times if there's other evidence as well, then that can help. And of course, if we had a customary practice,
Well, in
just
the face of
affidavit from a judge here, that would have been beneficial.
well, in the face of a strong statute like this, wouldn't that have made sense?
I think the problem here, too, is that if we're going to say that that's the only basis the Commonwealth has to reconstruct a record, and after so much time has passed, then we also have the problem of if there's a deceased judge, if there's a judge who doesn't respond to a letter, if there's
Justice
a judge...
Fina's question was, is there a prosecutor who's available who could have said, look, I sat through...
It's unclear who the prosecutor was at this point, because our records don't reflect who that prosecutor was. So we can look and try to...
Is that in the record?
Not on our part. There's nothing that I have suggests who the
Ms.
prosecutor
Klein,
was.
forgive me, you referred to Commonwealth against Birchall, and I don't see it in your brief, and so could you give me the citation to that?
It's in the brief.
It is?
It should be in the brief, Your Honor.
441 Mass 183.
Could I just ask a question? On page
Oh,
24.
Berthold. I thought you said Birchall.
Berthold,
Oh, Berthold.
yes. I'm sorry.
No, thanks. No, I know. I thought you were talking about the Birchall case, and I couldn't figure that out.
On page 24 of your brief, you mentioned at the time of his 07 motion for reconsideration, the defendant was not detained and was, quote, legally present, unquote. What do you mean by legally present?
Well, that's actually quoted from the transcript of the hearing, the motion hearing, the only transcript that we do have available, where the judge asked defense counsel whether the defendant, because he must have been at the court during this hearing. That's what I would assume that would mean. But the judge made it a point to say that he is legally present, and then reiterated that he has this lengthy record, that it was... The judge made it appear that it was unlikely that it was just this offense that was making him deportable. And in fact, looking at the notice to appear, the current notice to appear form from Homeland Security 5 convictions are listed. Notably absent is any reference to this conviction in this case. And I think that is something that's vitally important and shows that there's nothing.
Could you repeat that again, that thing that you say is vitally important?
I think that here we do actually have some type of notice from Homeland Security.
Is it in the supplement? Where is
It's
that?
it's in the Commonwealth Supplemental Appendix Number 2, pages 100 to 103. The first 2 crimes that are listed are assault and battery on a police officer and malicious destruction of property. Both of those are moral turpitude crimes, and those are just the first 2 listed from Homeland Security. We also have 2 violating restraining of protective orders, as well as a receiving or operating after revoked registration.
And what are these listed on, you said?
The notice to appear form, which is what any non-citizen, if they are going to be deported or are flagged by Homeland Security will send them a letter listing the convictions that they are basing, at that time, basing any type of immigration consequence on.
And this was the 1999 one, or is this?
No, this is the current. So we don't have anything in the record about what was
What's the date of that? Well, I just don't have it in front of me.
Yeah.
What's the date of that, the notice to appear? Sorry.
The notice to appear form looks like the date of that, the defendant was served with it February of '09. So at that point, he was aware of what he was being
And
going
this
to be
was
held on.
not one of the listed offenses? is
This
it?
was not notably absent
But
from that.
Ms. Contate says that during the hearing, this could come up. This offense could be a basis.
Well, we have no idea. That's a separate proceeding in itself from this. But what we do know is at this time, even if we're looking at the May language that the defense is focusing on in the statute, here it's not a possibility that at this moment, Homeland Security is causing the defendant to suffer from any enumerated consequence because of this conviction. And I think that is the center of this case, and that is what distinguishes this case from a hypothetical, because now here we know it's not a hypothetical, it's not even a possibility that it's this conviction.
Thank you, Ms. Lee.
Thank you very much.